Good day, Crime Talk aficionados. We have another great show for you today. First, an update on the Bryan Kohberger matter. An order just dropped. No sanctions for the KarenRead's attorneys. Lori Vallow is set for trial. Had another trial preparation conference. Kouri Richins wants a change of venue. A deadly weapon can be anything. In a story today, it happens to be a snake. We have this day in legal history and our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below, and make sure you hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket today for Tuesday, March 18th, I would ask you to go do this. Go to myskisign.com, all right? Go check this out. This is the nephew of the lovely Miss Kristen, and he has a great site here, all right? He's making a quality product. He's making a sign for me, and you all can have one too. So if you're into skiing or just love personalizing your own gear, this is for you. It's a site that's super easy. Take a look at this, where you can design custom ski signs. You can add your name, a favorite quote, or basically put your vibe on anything that's going to be highly crafted. It's going to be awesome. All right. Now, they've got sleek styles, durable materials, and it's super easy to create something totally unique. So whether it's for your ski cabin, your gear room, or just to flex your love for the slopes, go to myskisign.com and they're going to hook you up and you're going to be completely satisfied. Like I said, mine is on the way. Go check it out, myskisign.com, and it's your way of making your mark on the mountain. All right, let's go ahead and open the record for March 18th, 2025. I guess I already said that, but we have some breaking news in the Bryan Kohberger matter, and he has been denied again. All right, so there's a hearing scheduled for April 9th coming up. All right, and this is kind of interesting. Now, interesting in the sense of, well, why would the judge say we don't need to hear from the defense expert? The order says as follows: the court, having before its defendant's motion for leave to allow witness testimony at April 9th, 2025 hearing, has determined that the witness's testimony is beyond the declarations and is not likely to be necessary for the court's consideration on the issue before it. The information defense seeks to convey can be presented by declarations, which is basically affidavit or statements in their motions. Counsel may have the witness available by video streaming during this hearing, and should the court determine it necessary to hear from the witness, court may allow such testimony by live video stream. Well, here's the big part, ladies and gentlemen. So therefore, it is hereby ordered that the defendant's witnesses, Cy Ryan and David Howell, shall not be allowed to testify at the hearing being held on April 9th through the 10th of 2025 unless the court determines at the time of the hearing that such testimony is needed, in which case it may be produced by video live stream. Well, remember Cy Ryan? Remember, he was the expert that was going to prove that Bryan Kohberger was out driving around looking at the stars? Well, the judge is like, I don't need his testimony. Now, a lot of this stuff hasn't been released to the public yet, but clearly the defense is trying to establish something as it relates to the reliability of the records that were turned over by the police or the company, the cell phone record company, to the police. And that's what they're going to be arguing about. And judge is like, yeah, don't need it. But, if something comes up, have your witnesses ready. So Bryan Kohberger is denied. Now, does that help the prosecution or does it help the defense? It may just be a situation where the judge is like, this is a question of fact for the jury to decide. The prosecution is going to get to bring in their experts. You can bring in your expert to rebut what their expert says. In your case in chief, if you decide to prove one or put one on, even though the defense never has to prove anything in a criminal case. But this is not a legal issue that I need to take up that requires testimony basically as to the reliability. That's for the jury to decide who is telling the truth. Always an interesting time whenever the Kohberger case comes up on the docket. Next, KarenRead. That's right. KarenRead, who, for those who haven't been following the case, has pled not guilty to charges of second-degree murder manslaughter while operating under the influence and leaving the scene of a crash resulting in death. Obviously serious crimes. Now, the prosecution alleges that Miss Reed had backed her Lexus SUV in a drunken rage into her boyfriend, a Boston police officer at the time by the name of John O'Keefe, back in early January of 2022. This all happened after dropping Mr. O'Keefe off outside a Canton home following a night of bar hopping and drinking. Now, KarenRead's lawyers say that she's been framed and that O'Keefe entered the house owned at the time by a fellow Boston police officer, whereby he was obviously beaten by the police officers and as well possibly mauled by a German Shepherd before his body was planted out in the cold and snow out on a lawn at the house. Now, Read's lawyers have accused 3 witnesses of being involved in O'Keefe's deaths, none of which have been charged in connection with Mr. O'Keefe's death at all, other than Miss Reed. Well, Read's trial ended in a hung jury back in July. She's set to start trial in April. Well, we have had a series of motions hearings, and finally we got a little bit of closure, so to speak, on a couple of the issues. So the judge in the KarenRead case said today that she will allow 2 crash analyst experts to testify for the defense at next month's retrial, while she admonished Miss Reed's attorneys for concealing a financial arrangements with the analysts. The judge made a ruling from the bench and said that candor with the court is absolutely essential. She said, "A lawyer is only as good as his or her word, and I need to be able to take counsel at their word, so I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in a courtroom," the judge said. Now, she did reject the prosecution's motion to bar the 2 witnesses from the Philadelphia-based company Arca, and said that those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. Now, as you may recall, if you don't know or haven't been following the case, the Arca witnesses testified at the first trial that Mr. O'Keefe's injuries were consistent with being struck by a vehicle. Now, jurors were told that a third party had hired the analyst rather than the defense, which was technically true, right? The Justice Department initially hired them as part of the separate federal grand jury probe of state law enforcement's investigation into the death of Officer O'Keefe. However, the jury wasn't told that one of the Arca witnesses and Reed's attorney, Mr. Jackson, Alan Jackson, had discussed a possible retainer agreement back in March of 2024, about a month before trial. The correspondence came to light during discovery for the upcoming retrial. In addition, Arca sent a bill to the defense team for $23,000 weeks after the mistrial, and Reed's lawyer said that the bill came out of the blue and they weren't anticipating that bill, but they paid it anyway. Anyway, the judge said that Reed's lawyers filed the motion as recently as last month that described the Arca analysts as neutral expert witnesses, when in fact they knew that they had been compensated by the defense and they should have made that disclosure. The judge said in her ruling, "I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the Arca witnesses." She said that she would call Reed and the defense to a sidebar before deciding which sanctions were appropriate for that. And then following the sidebar conference, the judge said she would not revoke the pro hoc vice status of most of KarenRead's out-of-state lawyers to try the case. But she said, "I don't expect to have to address this again." Now, this is interesting, ladies and gentlemen. That was what the prosecution wanted, was to have the pro hoc vice status of KarenRead's defense attorneys, particularly Mr. Jackson, who made a lot of these misrepresentations, and they were misrepresentations. Let's call it what it is. And the judge is absolutely right. As an attorney, you have a reputation, and you have to have a reputation for providing truthful information. And if you don't, guess what? That reputation will go super fast. It's like a wildfire. And if a judge doesn't trust you, it can be ugly from there on out, okay? And I don't think I can speak to a case where, at least I'm aware of, where the judge said, "Oh my gosh, Scott is not being truthful in your duty of candor. I take my duty of candor very seriously when it comes to candor with the court." Like I said, I've never been a client worth going to jail for, and I've never been paid enough money to lose my law license. Just simply not something I'm willing to do. And the judge was right. These were misstatements. This financial arrangement should have been disclosed out of an abundance of caution. It should have been disclosed at the first trial. And we'll see. The problem, if the judge had imposed any further sanction for not allowing the attorneys to appear pro hoc vice as a guest in the Commonwealth of Massachusetts, they'd have to start all over again. There wouldn't be a trial starting in April. So that's why she did it. Now, I'd be curious if there was something up at the bench. Maybe there was some sort of punitive sanction or just this admonishment that took place. But when you get a tongue lashing from the judge and they're basically calling you unethical, that's not good. That's not good. And the judge is going to, take what you say with a grain of salt. So you better be absolutely accurate because, as the judge said, she doesn't want to have to address these issues again. Reed's attorneys got off with a slap on the wrist, okay? Should have been disclosed. Anyway, the judge also heard requests from Reed's lawyers to bar witnesses from the courtroom after they testify, including during closing arguments. Anyway, one of KarenRead's attorneys by the name of Elizabeth Little said that during closing at the first trial, prosecution witnesses Brian Albert and now retired Boston police officer who owned the residence at the time of the O'Keefe death, his nephew, Colin Albert, and his sister-in-law, Jennifer McCabe, were all seated with the O'Keefe family members. And apparently, at least one juror told Vanity Fair that they felt intimidated by their presence at closing, the attorney said. Anyway, Reed's lawyers have accused the three witnesses of being involved in O'Keefe's deaths. No one's been charged in connection with O'Keefe's deaths besides Miss Reed. Ms. Little also said there's information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there across from the jurors during closing arguments. The prosecutor rejected that assertion. Okay, let's just talk the way it is, right? Once a witness is endorsed, there's usually a sequestration order that says that the witness cannot talk to other witnesses about their testimony until after they've testified. Now, once you've testified, that order of sequestration no longer applies, and you can then come sit in the courtroom. But if something comes up, you can't be recalled as a witness because you've been sitting in the courtroom. The defense doesn't want these people back in the courtroom for closing arguments because it's going to intimidate them. Well, let me tell you what prosecution offices do. They will bring in all of the other district attorneys who aren't in trial and have them come stack the seating section in the courtroom to make it look like they're all there for the prosecution, right? The victim's family comes in, the victim advocates all come in, and there it is, just you and your client and maybe a family member or two, if you're lucky, sitting over there on the defense side. Do you think that's intimidating? It could be, right? Oh my gosh, look at all the people. They're so supportive of the prosecution. That's just the way it's done. Quit whining about it. Frankly, you want to have those people. So in closing argument, you can go over there, look at them, and point your finger right at them and say they were the ones involved. And watch them squirm. You see the way he squirmed, ladies and gentlemen? He was squirming. You know what squirmy people do? They commit murder. Just joking. A little exaggeration there. But I'm trying to express the point. Quit making motions that are just ridiculous. The judge is going to deny this in a heartbeat. All right. Like I said, Special Prosecutor Brennan rejected that assertion, and he said Reed's lawyers were taking an opportunity to provide an unsolicited bashing of their targets. They invoke their names, they characterize them as third-party culprits, and they suggest that some anonymous juror was uncomfortable. Anyway, Brennan said that the idea that these witnesses should not come in after the evidence rests and during closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, or in courtesy. And I have to agree with Brennan on that. See, I agree with the defense on some things. I agree with the prosecution on some things. That's called being intellectually honest, ladies and gentlemen. And usually the law, not every side gets exactly what they want. The prosecution usually gets mostly what they want, but not everything. Anyway, the judge said that she would take that argument under advisement. Additionally, she also heard brief argument on the defense motion to bar any mention of alleged harassment of prosecution witnesses by Aidan Kearney, a.k.a. the Turtle Boy, the blogger who championed Reed's claims of innocence, and he's pled not guilty to charges of intimidating and harassing a witness. Now, I was watching this hearing, and it almost seemed at one point as Mr. Jackson all but conceded the Turtle Boy was harassing potential witnesses, but Go take a look at the video yourself. You decide. Anyway, Mr. Jackson said the prosecution has convened a grand jury in an effort to pursue witness intimidation charges against Ms. Reed, who, according to court records, spoke frequently with Kearney back in 2023. Now, about a month before the trial, Jackson said the grand jury declined to indict Reed for witness tampering. At trial, McCabe mentioned the harassment she said her family endured, and on Tuesday, the judge said McCabe did that after Jackson's opened the door to the topic on cross-examination. Whatever the door was, it was some very significant lubrication, Mr. Jackson said. Read the transcript, the judge said. I have several times, Jackson responded. Mr. Brennan pushed back on the notion that McCabe used her testimony to expound on her family's ordeal, saying that it is unfair to stand up here at this podium and suggest for a second that Miss McCabe is using the witness box as some type of forum. Mr. Brennan said she didn't drag herself into this case. She was dragged into it, and to suggest they can stand here and bash witnesses because it pleases them and fits their narrative is something I just can't sit by and listen to. Mr. Jackson couldn't listen to Mr. Brennan without offering a response and said, I just wonder where this ire and these incentives from Mr. Brennan come from, Jackson said. Was he listening? I don't bash a witness. I don't attack a witness. I didn't make any fraudulent statements. The judge took the matter under advisement. At the first trial, she barred any mention of witness harassment unless the defense opened the door to it during cross-examination. That hearing is going to resume on Thursday. Now, Reed's lawyers are also appealing a federal judge's denial of the request to drop the murder and leaving the scene charges on the grounds that multiple jurors indicated that the jury unanimously agreed to acquit her of those counts and remained divided only over the manslaughter charge. Anyway, the state Supreme Judicial Court rejected the request in February, and a U.S. District Court judge in Boston followed suit last week. Not that I'm bragging, but just like I told you so. Anyway, Reed's lawyers filed an appeal to the U.S. First Circuit Court of Appeals in Boston, which set a March 24th deadline for the prosecution to reply in writing. Oral arguments before the First Circuit haven't yet been set, and they're not going to be set before the trial date either. So it's going to be denied, ladies and gentlemen. This is not a habeas type petition, but hey, when you got hundreds of thousands of dollars in GoFundMe stuff, you just keep plugging away at it. So bottom line is, I think I called it, right? Didn't think they were going to suspend the attorneys from their pro hoc vice status because otherwise that means the case gets delayed further. Nobody wants that. The habeas petition was denied, and all this other petty stuff, quit worrying about it. Like, just go try the damn case. Like Lori Vallow. She wants to go try her case. I've never seen a defendant so willing and able to get to court. Well, that's right. And Lori Vallow was in Arizona, where she faces charges for murdering her fourth husband, Charles Vallow, and conspiring in an attempt to kill her niece's ex-husband, a guy by the name of Brandon Boudreaux. Now, like I said, Lori Vallow was back in court just days before the Arizona murder trial is scheduled to begin. The two cases in Arizona are being tried separately, and Lori is scheduled to stand trial for Vallow's murder, and jury selection begins on that one on March 31st. And there was a lot of discussion about what can be brought up as it relates to Lori Vallow and her convictions in Idaho during the jury selection. But the judge says, hey, let's just wait and see. If they know Vallow, they're probably going to know about all that. And then we'll inquire in chambers. Like I said, the parties were set to discuss the status of outstanding discovery issue requests and some trial logistics. And Miss Vallow has also insisted that she wants to start her trial on March 31st, even if it meant her computer forensic expert would be unable to complete his investigation. She is ready to roll. I like that. Let's roll. It also came out that Ms. Vallow wants to call reporter Nate Eaton as a witness and is contemplating testifying in her defense. In her defense? I'm not sure what personal knowledge he has of the incidents. We'll have to wait and see, I guess. Nate, if you're going to testify, we'd love the big scoop. Call us. Call me. Next on the docket, Kouri Richins wants a change of venue. That's right, Kouri Richins, the woman charged with killing her husband back in 2022, is asking the court to move her trial from Summit County to Salt Lake County. Now, Richins' defense attorneys filed a motion to change venue on Monday, asking that her trial be moved to Salt Lake County, saying it would ensure a fair trial. Now, Kouri Richins is charged with the aggravated murder for allegedly poisoning her husband, Eric Richins, with a fentanyl-laced drink. Accidents happen. Anyway, her defense team say they conducted a survey, which is usually the first part of establishing a change of venue, is required if you can show that there is overwhelming media coverage and prejudice. Now, her defense team said they conducted a survey and Salt Lake counties to show the difference in the public's knowledge of her case and preconceived attitudes. The defense team pointed out that Summit County has a population of some 42,700 people, while Salt Lake has 1.1 million people. And according to the defense, the survey found that 79.8% of Summit County residents recognized the case, and 98% among those who regularly watched or read the local news. Of those who recognized the case, 69% reportedly said they believe Richins is guilty, and 50.3% said Richins would have a difficult time convincing them that she was not guilty. By contrast, only 42% of those surveyed in Salt Lake County recognized the case, and of those, 56.6% said that they believed that she was guilty. And 41% said it'd be difficult for them to convince her that she was in fact innocent. The defense also cited extensive media coverage on her case, especially a hyper-local level. And they said that the local news outlets have published roughly 140 stories on the Richins case since her arrest back in May of 2023. The defense also included an affidavit from a guy by the name of Andrew Bork. He's the firm's director specializing in crisis communications, litigation support, media strategy, and stakeholder engagement. That's the job I want to do. I want to specialize in crisis communications, litigation support, media strategy, and stakeholder engagement. Oh my gosh, that's what I do on a daily basis. Anyway, Mr. Bork said he conducted informal interviews and learned that some Summit County residents are afraid to go against the family of Eric Richins. The Richins family's influence has created an environment where those who question Kouri Richins' guilt are questioned as enemies. Community members have directly told me that anyone who defends Kouri Richins is considered an enemy of the Richins family. Now, the defense also said in their little survey that 26.6% of those surveyed in Summit County either had some sort of connection to Eric Richins' family or knew someone who does. However, only 3.5% in Salt Lake have such connections. And in his conversation with the Summit County residents, Mr. Bork said he believes fear of social and professional retaliation prevents anyone from publicly disagreeing with the prosecution or the family of Eric Richins. Now, jury selection is scheduled to begin on April 22nd. The trial is set to begin on April 29th in Park City, unless, of course, there's a change of venue request that's been granted. Next on the docket, you can't make this stuff up, ladies and gentlemen. Now, we've talked before, a deadly weapon can be anything. I've seen cases where deadly weapons have been a shoe, a pillow, right? You can cause serious bodily injury or even death with any of those items. Well, this story involves a snake. That's right. A gas station employee in Tennessee had a big story to tell the police. And guess what? He had video to back it up. So this incident goes back to March 4th at a Citgo gas station in Denmark, Tennessee, during which 4 alleged robbers used 2 ball pythons to threaten an employee. Now, the suspects, 2 women and 2 men, were not identified and allegedly made off with about $400 worth of CBD oil. Now, Mayor Raval talked about the incident, and Mr. Raval told everyone that he and his brother were both working on the night in question. Raval described what he can only be seen as a 21-second video. They were just waving the snakes around and putting them on the counter. One person brought in one snake first, and then the other brought in another snake. It was white and the other was brown or a mix. Anyway, the 4 suspects have been wanted for taking the CBD oil, which was displayed on the counter, but there were many customers around who think that it was a much bigger idea, that they plan to rob the store, not just taking CBD oil. And their snake was the weapon. Anyway, the 4 suspects left the store in a black sedan, the trunk which was secured by bungee cords. The car also had drive-out tags, and it was damaged to the rear of the vehicle as well. All right. On this day in legal history, March 18th, 1922, the United States Supreme Court upholds the 19th Amendment in the Lesser v. Garnett case, affirming women's right to vote and obviously making a landmark in constitutional law. There you go, ladies. 1922. It was affirmed. You have a right to vote. And on this date in 1940, the United States Supreme Court in Catwall v. Connecticut incorporated the First Amendment's free exercise clause to states, a key religious freedom precedent. That's right, applying to the Constitution to the states via the 14th Amendment. And on this date in 1963, on March 18th, the United States Supreme Court in Gideon v. Wainwright held that the Constitution requires states to provide attorneys for indigent, i.e. broke or incarcerated defendants. Now, Justice Hugo Black wrote the unanimous court decision and said, quote, "Any person hailed into court who is too poor to hire a lawyer cannot be assured of a fair trial unless counsel is provided for him." Now, unknown to a lot of people, but that was Gideon v. Wainwright said you have to provide an attorney to a defendant in a criminal case in the state if they're indigent. But guess what? Counsel had been required for indigent federal defendants since 1938 in federal court. There you go. And on this date in 1968, Congress abolishes the gold standard, shifting the United States currency laws and impacting financial crime enforcement related to counterfeiting. And finally on the docket, our dumb criminal of the day. A Georgia man opened the rear door of a police car and climbed in and told the cop that was behind the wheel that he wanted a ride home. Onward, Uber driver. This all took place Friday night about 10 p.m. when Andrew Davidson allegedly entered the car and shut the door while there was a human being, the officer, in the car. This all apparently took place in St. Petersburg. And what was interesting was when the gentleman got into the police car, well, guess what? The emergency lights were already flashing, according to the police. The defendant stated that he wanted a ride home. And that's all according to the charging documents of Mr. Davidson for trespassing that he was charged with. Mr. Davidson lives in Statesboro, a city about 55 miles from Savannah. It's unclear what Mr. Davidson was doing in St. Petersburg, but the officers noted that the man showed an indication of being under the influence of alcohol. Well, Mr. Davidson apparently sobered up, bonded out of jail after posting a $500 bond for the misdemeanor charge. I think the perfect defense is going to be mistake of fact. I thought it was an Uber, Your Honor. It had the lights. It was saying, come, we're open for business, like the taxi cabs used to have, right? Where they had the light on saying they were available for hire. That's the defense. But Mr. Davidson, you are a dumb criminal of the day. Keep your hands to yourself. Don't get into cars that don't belong to you, and you won't get arrested. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.